To Mr. Ivey for 5 minutes.
Thank you, Mr. Chairman, I want to commend you for having this hearing. You've done. I've only been on the committee for about 9 months now. I think we've done, of all of the hearings we've done, I think we've done 4 that I would put in the substantive category. 3 of them have been yours, and I greatly appreciate that fact. Thank you, ma'am, for coming today, and I appreciate the great work you're doing. I think we're in the hair-splitting segment of the hearing now. I'm going to follow up on some of the questions the chairman raised, but I'm trying to figure this out. I'm a lawyer by training, but not productive law. I did litigation. Unlike the copyright world, where you're helping actual creations be made and protected. But one of the things I was wondering about was, and I think you mentioned this earlier, so you've got sort of a human creator who generates, let's say, a song, and uses AI to help with there's a portion of the song that is in part generated by the AI, and that is AI that's been trained and ingested other information or music from other sources. And I think what you were saying was that the creator, when the human creator comes to seek a copyright, has to explain or disclaim that there was AI generation as part of the final overall work. Is that right?
Yeah, they would not have to disclaim the use of AI as a tool, like to provide a beat or that kind of thing, or to change a rhythm, but they would if there was let's say, a melody created entirely by AI that they incorporated into their larger musical work.
Okay. So we'll go forward with that. I've got a son that creates beats. He would disagree with where you drew that line right there, but we'll set that to the side. So the melody line. So, and let's say then that, because we've got people who approached me, for example, and they were complaining about AI being trained using their creative work product. And so in the song that you and I just made, and this author says, I had AI trained assistants in generating this song. How is it, or has there been a determination that's been made with respect to the people who helped create the content that was used to train the AI that was then used in this song? How are they copyright or compensated for their work, or is it recognized even?
Yeah, well, that's a critical question right now, and I know. And by the way, I'm a reformed litigator myself. I know there's a number of cases pending in the courts asking exactly that question. So assuming that the technology requires the reproduction of the works in the computer for purposes of the machine learning, there would be a prima facie case of infringement, and then the question would be whether it's fair use. Whether it's fair use might depend both on how it's used in the training and also what the output is going to be. And the extent to which it competes in the market with the original.
And to what extent is this all going to be reliant on, I think your term was honesty, I'll say honor code, but the individual who, and I'll preface the question with this, just in my experience, to the extent compensation and the dollars get bigger, the honesty and honor code gets sometimes marginalized. So is there, you mentioned some of this before, which is the certification gets signed and the like, but are there stronger enforcement and protections that could be out there for the creators of the original content that was ingested by the AI model?
Yeah, well, the honor issue and the accuracy in statements made to the government agency has to do more with the applications for registration. But in terms of litigation, what's interesting is I'm seeing that more and more some of the companies that are producing and distributing AI technology and tools are beginning to say that they will license the copyrighted content that they use. And some companies that create or license themselves copyrighted content are saying that they're now going to create AI using that licensed content. So we may be getting more and more people who are interested in making sure that there's no legal questions surrounding their use of copyrighted works to train the AI. But other than that, the way to keep people honest, I suppose, is these lawsuits that are being brought. Some of them as class actions, and we will see what the courts have to say about the legality of proceeding without a license.
Spoken like a true litigator, right? And then last question in relation to that, the CCB, I guess is sort of an alternative approach. So instead of going to court, they can choose this path, but it's voluntary. I did have a question about copyright trolls, but also on the point you just made. I mean, to what extent could that be an avenue where these sorts of disputes get hashed out in a way that, because again, a lot of the people who are musicians or writing songs aren't. Oh geez, I'm over my time. I apologize, Mr. Chairman. Aren't wealthy people. So
You're the second last, so if you're only holding up my questions, you're good.
thank you, Mr. Chairman. I appreciate it. But their ability to hire litigators is can be limited. Is the CCB an option or an avenue that might be a viable approach for them, or not so much?
The CCB would be a possible approach. The limitation is that they can't issue injunctions, so they can't order anyone to stop infringing, and there's a limit of $30,000 in damages. So certainly the other option, and the one that's been pursued so far, has been bringing cases in federal court where presumably, especially if it's a class action, there are lawyers who will get compensated at the end of the day if the action is successful. So I've been wondering whether we will start to see many cases involving generative AI in the CCB, but so far that has not begun to happen.
Thank you, ma'am. Keep up the good work, and thank you, Mr. Chairman, for your indulgence.